the matter of Microsoft Corporation and others in JJH Enterprise Limited.
Mr. Singer.
Good morning, my lords. As you know, I appear in the jurisdiction appeal on behalf of Microsoft with Mr. Leith, and Mr. Levy appears for value licensing, the respondent, and Mr. Williams is here for the Wolfson interveners.
Yes.
In the preliminary issues appeal, if I can call it that, for Microsoft is Mr. Holtz and Mr. Riordan and Mr. Hicks and Mr. Wilder.
Thank you.
My lords, there's a housekeeping point in relation to timetable, which I believe we need to address you on.
Yes.
So far as the jurisdiction appeal is concerned, my time estimate for my submissions this morning is approximately 2 hours. And I've spoken to Mr. Levy, who anticipates needing about an hour. And allowing for a brief reply, the hope is that one could then start the next appeal at approximately 3 o'clock this afternoon, subject to the court's views about that.
Yes. Okay, well, Mr. Singer, I'm very grateful to you for that. You obviously did get the message. You'll not be surprised to know that the court have been thinking about it and discussing it. Our preliminary view is that this is a pretty short point. I'm bound to tell you, our view is that it can be done in the morning. I'm not going to force you to do it in the morning, but it really doesn't strike me as something which needs to go past lunchtime, but if it goes a little bit past lunchtime, we're not going to get complained.
Yes, I understand.
So I think it would be helpful if you brought that in mind. And I'm assuming that that will leave enough time for the other appeal. So we'll be starting either at lunchtime or sometime in the hour or so after 2 o'clock.
Yes.
May we be released then in those circumstances?
Yes.
Thank you very much.
Mr. Hobbs. Right.
My lords, the issue which arises in the jurisdiction appeal is the scope of the Competition Appeal Tribunal's jurisdiction under Section 47A of the Competition Act. As you know, Section 47A is the statutory provision which confers jurisdiction upon the tribunal to determine claims for breach of competition law, i.e. the Chapter 1 and Chapter 2 prohibitions. And the question is whether that provision, properly interpreted, confers jurisdiction upon the tribunal to determine non-competition causes of action, in the present case concerning copyright. Now, in the judgment below, Mr. Turner KC described the copyright issues as being a central aspect of this dispute, that's paragraph 7, and those issues, he said, lie at the heart of the dispute, that's paragraph 8, and in the course of argument below, we've referred to this in our skeleton at paragraph 48, he commented that this is an unusual case. And we respectfully submit that he was right to characterise the present case as being unusual and the copyright issues as being central. And in that regard, I'd like to emphasise 2 particular points at the outset. The first is that the pleaded issues in relation to copyright, which, as you will have seen, essentially concern whether value licensing's reselling activities were lawful, amount to a cause of action in their own right. And when I say cause of action, I use that in the Latang and Cooper sense, namely that there are pleaded facts which would entitle either value licensing to a remedy, for example, a declaration of non-infringement of Microsoft's copyright, or looking at matters the other way around, which would entitle Microsoft to a remedy, a declaration for infringement and an injunction. In other words, my lords, the scope of the pleaded issues is exactly the same as it would be had value licensing brought a freestanding claim for a declaration of non-infringement, or if Microsoft had brought a freestanding claim, or indeed a counterclaim, for a declaration of infringement and an injunction. And my lords, the only difference is that no specific remedy is claimed for copyright infringement. So we say at the outset, this is an unusual case in that the non-competition issues amount to a cause of action, and that's the first important point. Secondly, the copyright issues as they arise in the present case are anterior to the competition claim. And what I mean by that is that unless value licensing succeeds on the copyright issues, it cannot proceed with its competition claim. In other words, if their reselling activities were indeed in breach of Microsoft's copyright, Value Licensing would have no claim for breach of competition law at all. And that's common ground, and as you know, that's what led to there being a preliminary issues trial, although there's a slight difference between the parties as to why the copyright issues are determinative in that way, and I can come back to that if I need to. But the key point which I'd like to emphasise at this stage is that it is common ground that there are self-contained copyright issues which have nothing whatsoever to do with competition law, and those issues need to be determined in order to ascertain whether a competition claim can be pursued.
So just to make it clear, so your submission is that exhaustion has nothing whatsoever to do with competition.
Well, my lord, the point is that the issues that arise in respect of whether there has been exhaustion or not, we do say have nothing to do with competition law.
Okay.
In the sense that it's a completely self-contained copyright dispute is what we say. And I'm going to take, the reason I apprehend that I may need slightly longer this morning is because I want to show you the pleadings in relation to some of the copyright issues, just to explain or make good the points I'm making now by way of preliminary remarks.
Struggling to see how pleadings can answer the question whether exhaustion has nothing whatsoever to do with competition.
Well, my lord, the point I'm making is that we say in this case, the way the copyright issues arise is that they need to be determined before one gets to.
I know you said anterior.
Yes, exactly, but in anterior and discrete. In other words, the determination of the copyright issues doesn't involve looking at competition law.
Okay.
And
is it right to say the claimants accept, set aside the law, that if they fail on the copyright issue, their claim fails?
yes, now
That's as a matter of their election or choice or their pleading, because it's not necessarily the case that if they failed on copyright, competition law is completely ousted in principle.
so, my lord, the position is this, that the claimants accepted, I'm going to focus, for reasons I'll explain in due course, I'm going to focus primarily, when we talk about the copyright issues, on the dividing issue and the non-programme works issue, because you're familiar with those as a result of the other appeal. In respect of those issues, it was common ground that they would be determinative. And that's in fact what led to there being a preliminary issues trial. It was initially floated as a suggestion by Value Licensing. Now they accept that their claim fails, their competition claim fails or doesn't even get off the ground unless they're right about copyright. There's a slight wrinkle in that they say the reason that it needs to be decided and is dispositive of the competition claim is because of causation. We actually say it's more fundamental than that, that if all of Value Licensing's reselling activities were unlawful, then they can't bring a competition claim because you can't identify a legal market, etc. So the short answer is yes, it's common ground that, at least in relation to those two principal issues, the competition claim doesn't arise unless they're right.
We may not have to decide that if it's common ground, but I mean, just testing your proposition, let's assume that copyright subsisted in all of these things. I mean, the existence exercise distinction first arose in relation to free movement of goods. It's been applied in competition law simply because you have an IP right and you're within the existence. Doesn't mean to say you can't infringe competition law.
Well,
block exemptions. You can have the way in which you exercise your legitimate right may infringe the cartel prohibition.
so, my lord, the reason it's important, in my respectful submission, to focus on the particular facts of this case is because what I want to demonstrate this morning is, in this particular case, the issues arise in a certain way.
Yeah.
And we say the extent of the issues and the nature of the issues are such that they amount to a cause of action. And it's common ground, and we say it's right as a matter of analysis in this case that all of those issues need to be determined before one gets the competition claim.
We understand that. I mean, it may be that the reason why they're determinative is not for us to decide.
Yes.
Maybe it's either a question of causation or it's because you say a matter of principle. That
Yes.
It's common ground for whatever reason.
It's common ground in relation to causation, and in my respectful submission, that would actually be sufficient for my purposes, in the sense that if it's accepted they can't prove causation, then there would never be a competition claim that one could pursue. In fact, we say, as a matter of competition law, there are other arguments as to why it would be a bar. Hoffman-LaRoche, for example, the court has explained that illegal products are not relevant to the definition of a market. So we would say here, if we needed to argue the point, we would say they do actually need to prove a lawful market in order for there to be an arguable case that there's a relevant market in which there's dominance, in which there's an impact on competition and so on. So there's room for argument about exactly where the legality point comes in, but they at least accept it's directly relevant to causation, and that would be good enough for the purposes of my argument.
You raise the points by way of defence to the competition claim, don't you?
No, my lord, that with respect, again, the reason I want to take a bit of time going through the pleadings is we say this actually arises out of the particulars of claim, and I'll show you that. But in any event, I would say if it were the case, and I don't accept this, but if it were the case that it were purely defensive, I would nonetheless make the same argument, which is when one's looking at the pleadings in the case, there are facts pleaded which give rise to a copyright cause of action.
If it's not raised purely as a defence, how is it raised?
I'll show you, my lord. I'll come to it very shortly, but it's paragraphs 20 to 21 of the particulars of claim, where they assert that what they were doing was lawful, and then they proceed.
But your answer to that must be by way of defence, isn't it?
Yes, our answer to that is by way of defence, but they are positively pleading, and we say
But
they.
when you deny something, that's by way of defence, isn't it?
Yes, of course, but
And whenever you deny something, you say, for that reason, we're not liable. In your definition, that's a cause of action, because you could say, you could claim a declaration of non-liability.
well, my lord, as I say, the short answer is it doesn't matter. We respectfully submit to the argument that we're advancing, where the point comes in. But for what it's worth, we do say it arises actually expressly. They have positively pleaded that what they were doing was lawful. You're right, we've denied that and said it's unlawful and in breach of copyright and so on. But we would say they actually rightly recognise from the very outset in this case that they need to establish lawful reselling. So it wouldn't change the analysis in terms of the argument, but as it happens, it is actually fairly and squarely pleaded and was pleaded from day one in the particulars of claim.
That's copyright lawful reselling,
Correct.
which is not necessarily the same as competition law.
No, so that's the,
But I mean, it's common ground that the issue arises in the particulars of claim, it's challenged in the defence, it needs to be determined, and it's an a priori determination that is necessary to decide whether the competition law claim proceeds.
exactly. That's as it were what I'm trying to convey at the outset. So just pausing there, we do say this is an unusual case, and the judge below was right to describe it as an unusual case, and we say it's unusual in two respects. One, it's not just any copyright issue, as it were. Actually, when I take you to the pleadings, you'll see that it's effectively everything that would be pleaded in a copyright action other than specific relief being claimed. So we say that's why we use the concept of a cause of action. All of the relevant facts are pleaded, as would entitle one to a remedy, which is not the case in other competition claims where non-competition issues arise. So we say it's unusual for that reason, and then further it's unusual because of the a priori point.
But I think it seems to be common ground that you have to decide the IP issue in order to establish one way or another the competition claim.
Yes,
That's both your argument and their argument.
yes. And yes, that's the position. And we say
That's
that
a narrow point, really.
it's a narrow point, but it's an important point, my lord, because it has consequences not just for this case, but other cases too. And we say that actually one of the points I'll come on to is Mr. Turner's decision in part relies on the fact that no specific relief is claimed in respect of the copyright issues. But actually, as a matter of analysis, any relief that's granted on the competition claim would implicitly involve a declaration that they're not infringing Microsoft's copyright. So all of these issues, I'll come back to as it were to try and.
But you could have a finding in a judgment which isn't then manifest in a declaration or any final relief,
Yes.
which decides the copyright law issue, and it may be a matter of domestic law raised judicata whether that has
Yes.
any impact or not.
Yes.
But it's not, there's no remedy formally
No.
in relation to copyright.
No, and but we criticise the judge because we say that's a formalistic approach. So can I just explain? We put this point in two ways. So we advanced two arguments before this court, because as you know, Mr. Turner took the view that the copyright issues fall within the scope of the tribunal's jurisdiction, and the basis for that conclusion one sees at paragraph 13. He says the proper interpretation of the legislation was that the tribunal should have all issues that arise in the context of a claim under section 47A. And he said, just as the tribunal has jurisdiction to determine questions of causation and limitation, so it can also determine the copyright issues in the present case. So that was his judgment. And we say essentially two things. We say, first, we say his argument and his interpretation of the legislation was wrong because it's common ground, and indeed is the case, that the tribunal would not have jurisdiction to determine a freestanding claim for copyright infringement or a counterclaim. And we submit, if one's construing the legislation with a purposive approach, Parliament cannot have intended to confer jurisdiction on the tribunal to determine the very same copyright issues that might have formed the subject of their own claim. And we say it's entirely formalistic, coming back to the relief point, for the tribunal's jurisdiction to depend on whether or not specific relief is claimed in respect of copyright infringement. We say the analysis should be substantive. And we say if Mr. Turner's decision were correct, it actually leads to an odd outcome because it results in a specialist tribunal established for the purposes of determining competition law issues, making substantive determinations as regards rights and obligations which have nothing to do with competition law. They arise under intellectual property rules.
And any other legal regimes such as contract?
Well, again, we say the dividing line, and this is important because some of the submissions that we see from value licensing, and indeed in the judgment below, are taking our argument too broadly. So we're not saying, and I should be clear about this at the outset, we are not saying that the tribunal doesn't have jurisdiction over non-competition issues. What we say the dividing line is where one sees that the cause of action test is satisfied. And that's really our primary argument because, so for example, Mr. Turner's analogy with causation and limitation, we say with respect that's a false analogy because of course in a claim for breach of competition law, one has to grapple with a question of causation. I mean, that's intrinsic in the competition claim. And it's an essential ingredient of any competition claim, competition being a breach of statutory duty. But in contrast, we say the copyright issues here, they're not intrinsic to any claim for competition law. They arise under separate rules. And in this particular case, again, there may be other cases where intellectual property comes into a competition case, but we're not putting the point as high as that. We're simply saying here, if one looks closely at the issues, we say the cause of action test is satisfied. And so this becomes, we say it becomes an entirely formalistic decision, that the only difference between this case and a copyright case that would be ordinarily brought in the High Court is that no specific relief is claimed. And I think, my Lord, you alluded to the issue estoppel point. The reason we say this does lead to a very odd outcome is A, the specialist competition tribunal ends up adjudicating upon issues that otherwise would go off to the specialist IP list. That's odd, we say. But secondly, there would be an issue estoppel in respect of these copyright issues so that the parties couldn't relitigate them in the specialist court. But if an injunction were sought, for example, to restrain the breach of copyright, that would have to go off to the High Court. So we do say his interpretation of the legislation was too broad.
You say it's odd. Do you say the CAT is intellectually inferior to the High Court in deciding a copyright issue?
We say ultimately this is a question of statutory interpretation, and we say that the CAT was set up to determine competition law cases.
And is it inferior in deciding a copyright issue?
Well, my Lord, I wouldn't say it's inferior, but I'd simply point to the fact
It's a bit tricky because the president of the CAT will talk to the Chancellor and they'll find an appropriate judge.
No, but my Lord, we say there's a specialist IP list. And so one's construing the statute, and as I'll show you, it's been recognised in the cases, the CAT exists to determine competition law disputes, and the IP court exists to determine IP disputes. And so we do say it's odd for the competition tribunal, where these issues are self-contained, we do say Parliament cannot have intended the Competition Appeal Tribunal to determine essentially what is a self-contained copyright dispute. And that's why we say the cause of action test, I keep coming back to that, on our primary argument, that's the bright line. that it's not just can the CAT deal with a contract issue or an intellectual property issue, it's did Parliament intend for the CAT to be adjudicating upon copyright issues where they go this far?
If you're looking at parliamentary intent, presumably there must be something in a statute which carves out from a competition law case something which is derivative of which gives rise to a cause of action in something which is non-competition law, such as IP. You don't find that in section 47, do you?
You don't, no. I mean, in my submission, the wording of 47A actually doesn't support either side's case. It simply says, I'll come and show it to you, but in a moment. But it says, it refers to decisions in respect of infringement decisions or allegations of infringement. It's focused on competition law, which is why we say one has to apply a purposive approach and take a step back and consider whether Parliament can have intended the CAT to be adjudicating on these issues. But the second way in which we put the point on appeal is, if I call it my alternative argument, so that even if you accept the judge's interpretation of the legislation and the CAT does have jurisdiction to determine all issues that arise in the context of a competition claim, we say in this particular case, because the copyright issues are anterior, we do say there's an error even applying the judge's own interpretation. And the reason for this, and I'll come back to it, but the short point is, we say, with respect, it's entirely circular, because whether or not a claim for breach of competition law could be pursued depends on the outcome of these copyright issues, as we've discussed. And so we say it's circular for the tribunal to say, well, the CAT has jurisdiction in respect of the copyright issues because it has jurisdiction in respect of the competition claim, because there is no competition claim depending on the outcome of the copyright issues. So that's why we say the main point is that he's wrong about the interpretation of the legislation, but the alternative argument is even applying his interpretation, the way the issues arise here means that the CAT doesn't have jurisdiction.
Presumably on your point about anterior, it's a matter of competition law that the copyright law is anterior.
I'm sorry, my lord.
Presumably, you make the point that the copyright issue is anterior. Presumably, it's a matter of competition law that the copyright issue is anterior to this competition claim.
Well, it's not a matter of competition law. It's the claim is a breach of statutory duty claim, and they need to establish that they were not infringing in order to bring that.
But it's competition law that says they need to establish that. If they want to pursue the competition claim, yes. I mean, they're trying to bring a competition claim. Obviously, I accept that's what they're trying to do. Yes.
But we say it's a slightly bootstraps argument to say they're bringing a competition claim. Before they can bring the competition claim, they need to succeed in relation to copyright issues.
But the point I'm putting to you, Mr. Singler, is it seems to me at least, and I think I'm not trying to hold you to what I think you said, but I think you did agree, that it's competition law which is providing that they need to win the copyright issue.
Yes, because they need to show a lawful market and causation, etc., etc. But I do maintain that it's not. That's right. That it's because they want to bring the competition law claim is why there's this copyright dispute. But my point is, it's not an essential element of competition law generally to have these copyright issues resolved. And so one's looking at the position here as being actually quite different to most competition cases where you have this non-competition dispute before you get to the competition law claim. So what I was hoping to do this morning is to first show you the pleadings. I said I would do this, and just to give you a flavour of why we say, focusing on the two issues, the non-programme works and dividing, why we say they do amount to a cause of action, because that's important to the first point. And I know you're familiar with the copyright issues, having read the materials for the other appeal, but in my submission it's important as an exercise to examine the pleadings, because in most cases the jurisdiction issue would be determined at the pleading stage rather than with the benefit of a judgment. And then I was going to develop my submissions on the interpretation of section 47A, what I've just described as the primary argument, and then come back briefly to the alternative argument, and then say something very briefly about Wolfson. But with respect to the Wolfson interveners, we say their submissions don't ultimately add anything to the arguments already before the court. But we do say, insofar as they're here to make the point that the consequence of our argument would be to undermine substantially the effectiveness of the collective regime, we do say that's all overstated in the sense that, again, it fails to understand the narrow point that we're making. So
As you do that, can you just, don't answer it now, help us with the point that concerns us, which is you craft your argument on the basis of a cause of action in copyright. It might be said the same thing applies to contract law in relation to Section 2 and cartel arrangements, where you have to look at, amongst other things, the object and the content of an agreement, which might involve you determining the scope as a matter of contract law of what an agreement is, to decide whether or not there is a cartel infringement. So you have there might be a discrete national law issue as to the scope of a contract.
Yeah, can I just answer that particular point now? I mean, we say in relation into this, one needs to be slightly careful about hypothetical examples, because one does actually need to look at the cases quite carefully. But in relation to that particular example, we would say, of course, the CAT would be able to interpret a contract. I think interpretation is one of the points referred to by Mr. Turner in his judgment. And again, we say that the interpretation of a contract would be fine, but it's common ground that a breach of contract claim could not be brought in the CAT. And so if a breach of contract claim without the damages element were brought in the CAT, we would say that would be within the cause of action test that we expound. And so that's why one needs to be very careful about the scope of our argument. I do emphasise that the cause of action test that we're advancing would actually mean that very few cases are likely, as it were, to fall outside the scope of the CAT's jurisdiction, because it's actually very rare for non-competition issues to arise in the CAT in this way.
Why doesn't an interpretation of contract involve a potential cause of action? You can seek a declaration as to the meaning of a contract.
Yes, but my lord, in my submission, if one's looking at the Latang and Cooper approach of facts, pleading all facts entitling one to a remedy, there would need to be a breach alleged in order for that test to be satisfied.
Often get claims declaring the meaning of the contract.
You do, my lord. I mean, obviously the court can just interpret a contract, but on the cause of action test, I would respectfully submit, if the point arose, that wouldn't be a cause of action if one simply said to the court.
You said it'd be a cause of action if it's a claim for a declaration of non-liability.
For non-infringement, my lord.
Non-infringement.
For non-infringement, we do.
Non-liability.
So in this case, my lord, there obviously one can look at it either way around, but we would say if Microsoft is right on these copyright issues, it would be entitled to a declaration of infringement, but also an injunction to restrain the breach of copyright.
But in a competition case, if a particular arguments have been advanced as to the way the contract is to be interpreted, and the defendant not only seeks to defend on the basis of their contrary interpretation, but also seeks a declaration that they're right, why isn't that a cause of action?
Well, that would also raise other issues about the ability of the CAT to grant declarations. But it's certainly the case, my lord, that if one focuses on a breach of contract, it's clear that the CAT couldn't determine a breach of contract claim or counterclaim.
I've got a question as well, Mr. Singler. I'm so sorry.
Yeah.
What about McGill? You know the McGill case?
Yeah.
Isn't that a case in which infringement of copyright was fundamental to the competition law case?
Well, my lord, this is why it's quite difficult to go through all examples. We say the first point I'd make in response to that is it's actually quite rare for competition law claims to raise non-competition law issues in this way. I do understand that there is an interface between intellectual property, particularly in the refusal to supply cases and so on. But in those cases, I do understand it's quite common in a refusal to supply context, for example. Someone alleges a breach of competition law in respect of the refusal to supply, and the defendant might say, I have an IP right. But I wouldn't say, in my submission, and again, one needs to be slightly careful without having the exact issues before us, but in that case, I would say that wouldn't be, the cause of action test wouldn't be satisfied. If a defendant is simply saying, I'm entitled not to supply because I have an intellectual property right, I would say that's different to what's going on here, where there's an issue about whether or not Microsoft's copyright has been breached. So simply saying I'm entitled to refuse to supply because
You're putting McGill in that category, are
yes, my lord.
Okay.
Yes. So in those cases, or in that line of cases where a defence to a refusal to supply is the dominant undertaking says I have an intellectual property right. In my submission, those would be in a different category because that then goes to whether or not they're entitled, as a matter of competition law, to refuse.
I mean, I'm bound to tell you, I'm not sure I would have described McGill like that, so I'm just telling you now, I might go and have a look at it myself, so you might want to do the same thing.
Yes.
I think so, maybe it's right, but it doesn't,
Yes.
I don't remember McGill being that exactly.
No, I likewise can go back and check, but I don't recall in McGill there was an issue about whether or not there was valid copyright. My recollection of the case is that it was a refusal to supply allegation to which, and this does arise in other cases, so I'm not, as it were, trying to suggest that McGill is the only case. I do understand there are refusals.
It was a refusal to license. That's why I'm jibbing at it wasn't about McGill not selling, well, I'm not sure it was McGill actually, but it wasn't about the person with the copyright not providing a product. It was about them not giving a license, in other words, a permission to render an infringing act non-infringing. That's why I'm interested in McGill. I mean, just because I've been trying to dredge it out of my memory because it's an old case and I used to know it much better than I do now. But I will go and have a look at it.
Yes. Well, as I say, we do consider that this argument doesn't. I think the way this point arose. I mean, our position is we don't anticipate that this cause of action test would lead to, as Mr. Williams is submitting on behalf of Wilson, substantially undermining the regime, or meaning that there's a whole swathe of cases that the CAT wouldn't be able to adjudicate upon. We anticipate, in fact, it's quite difficult to conceive of many examples where our cause of action test would be satisfied because other competition claims just don't generally give rise to non-competition issues in this way. And there's a particular issue about IP. I do accept that. But even in the IP context, our position is we don't see many cases like this. And in fact, neither side has identified a case where the IP or the non-competition issues have arisen in such a stark way.
What about vexatious use of trademarks or patents by undertakings in a dominant position? I've got Boozy and Hawks in the late 80s. I mean, that was... Yeah. Isn't that something we put forward in this category? No,
you see, with respect, no, because I can see what it's being said by my learned friend that our argument is that all of those sorts of cases would then suddenly fall outside of the CAT's jurisdiction. But with respect, that would misunderstand the scope of the argument, because if there's a case such as the one you've just referred to, the question is whether it's abusive to enforce, I think it's a patent case, or to pursue litigation. And the competition law question is that type of conduct an abuse? What there isn't in those cases, as far as I'm aware, is some suggestion that, or challenge to whether or not there was the intellectual property or the right to begin with.
But there's well, we probably ought to look it up, but as I recollect, I think it was a patent, and the question was whether or not it was abusive to bring the litigation to enforce what was otherwise a valid patent.
Yes, exactly, but my point is it's accepted that it's otherwise a valid patent. That
becomes invalid if it's vexatiously used.
Yes, but
that was a competition law issue, effectively exhausting the right. It's not
well,
the same language.
I wouldn't necessarily accept that last point about effectively exhausting the right, because I think one needs to have to go back and look at the detail of that particular case. Yeah. But what we say is the dividing line. We wouldn't accept that our line of argument would capture cases where someone's praying in aid the existence of an intellectual property right. We're actually saying here there's a freestanding dispute about whether or not there was a valid copyright, exhaustion, etc. It's not proceeding on the basis that
traditional non-competition law terms.
Exactly. Yeah. That's the distinction.
Well, coming back to Parliament's purpose, why would Parliament, applying a purposive construction, introduce these incredibly subtle distinctions between different types of IP involvement in competition law.
Yeah.
Why would it do that?
Well, with respect, we wouldn't pose the question in that way. I mean, we say, we put the point the other way around. What is Parliament trying to? Because one has to take a step back and recall Section 47A is not an exclusive jurisdiction on the CAT. So it's not saying all such claims for breach of competition law must go to the CAT. It's positively conferring, in addition to the High Court, jurisdiction upon the CAT. And we say, what is Parliament intending to confer jurisdiction in respect of? And we say competition law issues. Now, competition law issues or competition law claims might give rise to non-competition issues. And one can see, therefore, that the CAT's jurisdiction needs to extend to certain non-competition issues. But what we say Parliament cannot have intended was for something to be within the jurisdiction of the CAT when that very same dispute, if Microsoft had said we want an injunction for breach of copyright, it's common ground that couldn't be brought in the CAT. And we say it becomes actually quite artificial to say that these issues, which would create a res judicata, it does lead, in my submission, to a very odd outcome where you have a specialist competition tribunal essentially determining something that otherwise the CPR would say should go to the IP list.
I mean, again, come back to what Parliament intended, assuming there are two jurisdictions in which the issue can be litigated. Once it's in the CAT, why would Parliament want to take out a little bit, transfer it to the High Court, allow that to be decided, and then come back as a binding precedent for the CAT? I mean, that's somewhat inefficient, isn't it?
Well, but one has to look at this.
You're not saying that the CAT couldn't decide this case. That's just a matter of appointment of a judge who's a specialist with a non-specialist team of judges around him.
But in my respectful submission, it wouldn't be appropriate to approach this question of what did Parliament intend by reference to whether or not a specialist IP judge could be found to sit in the CAT. I mean, if one has to proceed on the basis that Parliament's setting up a specialist tribunal, as the case is recognised, to determine competition law issues. I mean that's clear from 47A. It's the reference in 47A is to infringement decisions or alleged infringements of competition law, and the cases have recognised, for example, and I want to address you in more detail on Unwired Planet, but it has been recognised that essentially there is a specialist IP list, and so when one's talking and all this case, to be clear, this case could have been, indeed it was brought in the High Court on day one, and then one had the transfer. That's a particular circumstance that arises here. But there's no suggestion, as it were, that fragmentation is an inevitable consequence, because the claim could be brought in the High Court, and all of these issues could be determined in the High Court. That one of the cases in the bundle Sport Radar, actually one sees a competition law claim brought in the CAT, some tortious counterclaims, which it was accepted had to stay in the High Court, or had to be pursued in the High Court, and there was fragmentation. Mr. Justice Roth said the case had to be case managed in that way, with the competition law claim proceeding in the CAT and the non-competition claims proceeding in the High Court. So we actually say, my lord, it's actually quite simple in the sense that Parliament plainly intended the CAT to determine competition law issues, and Parliament didn't, we know, and it's common ground, and we know Parliament didn't confer jurisdiction upon the CAT to determine a copyright infringement dispute. And we say, and that's why we do stress this is an unusual case, that the copyright issues or the non-competition issues in this case, apart from the fact that no specific relief is claimed, it's essentially the same as a freestanding claim we submit.
And I could see that would have force if the collateral issue was, say, landlord and tenant. As you remember, there were hundreds of cases back in the 90s involving pubs and exclusive purchasing and landlord and tenant. And almost every case had landlord and tenant issues and competition law issues. But here we're dealing with IP, with which competition law has grappled for decades, including with the concept of existence and exhaustion.
Yeah.
It's integral to the way competition law has evolved.
Well, the first, I mean, just 2 points in relation to that. The first is the argument doesn't depend on whether or not this is copyright, because we say the cause of action test should apply generally, and so one could test this by reference to some other tort. I mean, it's actually quite difficult to conceive of examples, but the logical consequence of the argument is whenever there were enough pleaded facts as to give rise to a remedy, So let's just take any other breach of statutory duty. If someone was saying you've committed a breach of statutory duty, and that arises in connection with a competition law claim, we would say, well, you couldn't bring that tortious claim in the CAT if that was your only claim. Why has Parliament intended the CAT suddenly to have jurisdiction over that? Because there's a competition law claim associated with it. So it's not just a copyright specific point. And then to your reference to the fact that IP and competition law have gone hand in hand for many years, we do accept that. But again, we say there aren't that many cases which would satisfy this test. And it's actually, as the judge below himself recognised, this is actually unusual, where he said copyright or IP is at the heart of this dispute. It's actually a very unusual case, which is why I was about to show you the pleadings, just to make good that the pleadings won't. We say the pleadings are exactly as they would look in a copyright claim brought in the High Court. Can I very quickly show you the particulars of claim to begin with? This is the joint core bundle tab 15. And then obviously at the beginning of the pleading, one sees a description of, I know your lordships are familiar with the allegation of campaign and so on. It starts at paragraphs 1 to 3. So the competition allegation is a campaign to stifle the sale of pre-owned licenses. And what's alleged is an abuse of dominance and a breach of the prohibition on anti-competitive agreements. And then you see paragraph 20 and 21 are the crucial paragraphs. So they've accepted earlier on in the pleading that Microsoft owns the copyright in the relevant software. And then at 20, purchasers of perpetual software have at all material times been entitled to resell those licenses. This is the effect of the software directive. And then references to exhaustion in 20, subparagraph 1 and 2. And then 21, as a result, at all material times, perpetual licenses could be lawfully resold. And so we do say, looking at paragraphs 20 to 21, we say that the copyright issue does arise out of the claim because they're positively averring that these licenses could be lawfully resold, and you'll see the reference to the software directive. And we say the structure of the pleading reflects the fact that they recognise that this is a necessary building block to the competition claim. And this also demonstrates that it's in the particulars, that this issue has been in the pleading since day one, although, as you will have seen, the pleadings then developed over time, ultimately culminating in the preliminary issues trial. And then in relation to the defence, where I appreciate that these points are developed in much more detail, I'm just going to show you in relation to the non-programme works issue and dividing issues. And as I said earlier, one can test the argument by reference to those two issues, although there are some other issues in the pleadings. And we do say it's important to look at the pleadings. So non-programme works, if you look at the defence, which is tab 16, and if you go to paragraph 13, so this is pleading back to paragraph 11, where Value Licensing had said Microsoft has the copyright. So 13.1, and then you'll see over the page a pleading as to Microsoft's rights as the copyright holder. You'll see, for example, it's C over at the top of the next page. Insofar as the first defendant, the owner of copyright, has the exclusive right to do all of the acts restricted by the copyright. And then absent a license from the copyright owner, the doing of any such act would amount to an infringement of the copyright. And then there's a long section, I don't know to what extent your lordships have had a chance to look at this, but 23A, you'll see starts, the defendants rely on the following principles and propositions of law in opposition to the claim of right and contention of lawfulness made in and under paragraphs 20 and 21, which I showed you. And I'm just going to focus on some paragraphs now in relation to non-programme works, and I'll come back and do this in relation to the dividing issue. But 23A.2, you'll see the argument is that the software directive is limited to computer programs. I mean, obviously you're going to hear argument in detail about these points, but I'm just showing you the pleadings. So there's a debate about the scope of the software directive, and Microsoft's case is that in fact it's the InfoSoc directive which applies, and you'll see this at 23A.7 on the top of page 251 and 23A.9. So the argument is the software directive is limited to computer programs. That doesn't extend to graphical user interfaces. The InfoSoc directive applies to the non-program works, etc. So, but I'm just showing you the extent to which all of this is pleaded out. And then 23B, if I could show you B and C. So the claimant's assertion at paragraphs 20 and 21 that it's lawful to resell and there's an entitlement to do so is unsustainable. And 23C, the claimant's generalised assertions at 20 and 21 fail to take account of the specific features of the business, which have the effect of precluding any lawful right or entitlement to do any of the following acts. And then, if I could just lastly take you to 24A.5, which is core bundle, page 260. You'll see a reference to non-program works and then an entitlement on the part of Microsoft to restrain, and in respect of which it could have brought an action against the claimant for copyright infringement, 24A.5. And 24B, similarly, denies that they had a right lawfully to engage in its dealings. And I should perhaps show you paragraph 40 is where, so 40.1 on page 269 is a pleading in respect of market definition. So this comes back to the point about where the legality or otherwise fits in as a matter of competition law analysis. We've pleaded at 40.1 that it renders the market definition exercise OTOs if all of this is unlawful. So that's 40.1. And there's a causation plea. Go to 64.2 actually. I should show you 64.2 on page 280. We say there can be no appreciable effect on competition insofar as acts are prevented which would have been infringements of intellectual property rights that the defendants would have been entitled to restrain.
So which paragraph was that again?
Oh, I'm sorry, at 64.2b on page 280. And then finally in the defence, just the causation argument is at 68a. So that we say that this point about legality comes in various different ways. I just wanted to show you how the copyright issues on non-programme works were pleaded in the defence. And then can I just...
Have you pleaded ownership and subsistence of copyright?
I'm sorry, my lord.
Have you actually pleaded ownership and subsistence of copyright?
Yes,
You say you didn't read that one. You showed us paragraph 11.
Sorry, my lord. I think the best way of... so I should perhaps have shown... I showed you paragraph 11 of the particulars. I don't think I actually took...
Paragraph 11 of the defence.
Yes.
Sorry, paragraph 13.
Yes, responding to paragraph 11, but perhaps I should...
Insofar as...
Yes, but my lord, I should have actually shown you 11 of the claim, because this is not in dispute. 213 of the core bundle.
So it's an admission that there's ownership in
Yes.
paragraph 11.
Yes. Yeah. I mean, that is not, as I understand that, that's never been in dispute, that Microsoft does have the copyright. And Can I take you to the reply? And I apologise. I think it's more logical if I just follow through the non-programme works issue and then come back to divide it. But if I show you the reply at tab 17. So the reply is 22 pages and it only deals with the copyright issues. And well, obviously won't take you through all of it, but at paragraph 2, you'll see, as page 287, as pleaded at 20 of the particulars of claim, the first sale of a copy exhausts the distribution right, so that's with reference back to particulars of claim. And then there are various paragraphs that deal specifically with non-programme works. So if you look at 3.4 on page 288, I'm taking this quickly because I know you're familiar with the arguments, but I do maintain it's useful to see the pleadings. So 3.4 is the argument about computer program works, and if I then take you to 8.1, and if you go over the page to 291 in Roman 2, you'll see 3.4 is repeated. It's denied the items characterised as non-programme works necessarily fall to be treated as separate copyright works. And then 12 and 13 are interesting because this is the response on paragraph 23A of the defence. And again, one doesn't need to necessarily focus on all of these paragraphs. It's just to give you a flavour of the fact that this is joining issue on essentially everything that Microsoft has said in relation to exhaustion and non-programme works. And just two more references on non-programme work. So if I take you to 15.1, you'll see that the nub of the argument on non-programme work. So VL says, not provided proper particulars of the works, so you're required to prove the non-programme works, that copyright subsists in them, and that they're properly to be analysed as separate copyright works rather than integral part. And then over the page, without prejudice to that, they rely on their propositions above, and they say that non-programme works are integral parts of the computer programme works. And then one can also see they actually deny the entitlement to restrain. So I showed you 24A.5 in the defence, and that's all denied at 17.5. So on non-programme works, and if one's looking just at the pleadings, we do say there's a self-contained issue of copyright law. There's a fundamental dispute as to whether value licensing's practices were ever lawful. That they don't accept there were any non-programme works, and they require Microsoft to prove them, prove the copyright, and whether they're to be analysed as separate copyright works. And Microsoft says the right of exhaustion under Article 4.2 of the Software Directive doesn't apply, instead the InfoSoc Directive applies, which obviously you'll hear much more about. But the punchline is that if Microsoft is correct in relation to all of that, then it follows that value licensing has infringed Microsoft's copyright. Microsoft would be entitled to restrain, and that's why we say this is tantamount to a cause of action, because Microsoft's in fact pleaded that it would have an entitlement to restrain, but it hasn't claimed the injunction in the prayer for relief. And so,
but what you actually do plead are various consequences of the copyright arguments. For instance, 40.1 defence, 64.2b, 68.a,
yes,
where you say, right, based upon those copyright arguments, the competition claim fails,
yes,
and that's why this is a defence to the copyright claim. Sorry, to the competition claim.
Yes, well, yes, I mean, the way this arises, you're right, is that they want to bring a competition claim, and we say you're not entitled to because you've been
quite
breached.
specific ways. At each stage, you say that as a result, the market doesn't encompass any activities that amounted to infringements, etc. So at each stage, you rely upon it to defeat the competition.
That's right, my lord. I mean, as I said earlier, they accept that it would defeat the competition claim on the causation basis. We say it's wider than that, and that's why it appears at various places. But I do say, my lord, for the purposes of this argument, it doesn't matter whether one looks at this as arising out of, one could say this arises out of the claim, because they can't bring the competition claim unless and until they succeed on the copyright issues. Or you could say it arises out of our defence, because we have denied.
They didn't have to plead. They didn't have to plead that the lawfulness in their particular claim, did they? Or indeed, if they had pleaded it, you could have admitted it. When the issue only arises because you take the point in your defence.
That's right, my lord. As it happens, they have in fact positively pleaded it, and we say they rightly recognised in paragraphs 20 and 21 in particulars that it is a premise of the competition claim that all of this was lawful activity.
But that's the premise of almost any claim, is that your activity is lawful. Otherwise, the defence can come back and say your claim fails for illegality.
Yeah, but my lord, I wouldn't accept for the CAT's jurisdiction that it matters actually whether this comes up in the particulars of claim or the defence.
Well, I thought you started off by telling us that in fact they had pleaded it, and that was one of the reasons why you wanted to show us the pleadings. But
Well,
I can't actually see that it does really matter.
no,
They didn't have to plead this. You didn't have to deny it. It all arises from your defence, where
Yes.
you take these points and say, as a result of these points, your competition claim failed.
yes, I mean I don't.
It seems to me it's a classic defence to a competition claim, isn't it?
Yes, but when one looks, the point I'm trying to convey is that when one looks at those copyright issues, before one gets to whether or not they're in defence to the competition claim, that is a self-contained copyright dispute. That's really the point I'm making.
I don't think there's much between us, is there? It arises as a defence, didn't have to, you could have admitted it, but it does. It addresses a competition law claim, in particular, definition of the relevant market. As it happens, it also amounts to a discrete issue in relation to copyright, which could give rise to declarations or remedies in any event, had it been raised as a claim.
Yes. So the way of testing our argument, I would respectfully suggest, is if one looks at what I've just shown you, and we say those are issues that would ordinarily be litigated in the IP list in the High Court. Now we say we say if Microsoft had actually brought, as in fact they did, bring an application or a claim in the High Court to restrain value licensing, all of that would be absolutely squarely within the scope of the IP list jurisdiction. And does it change? Should the CAT have, did Parliament, ultimately one's asking whether Parliament intended the CAT to have jurisdiction, if one just focuses on the issues I've just taken you through in the pleadings, did Parliament intend that the CAT would have jurisdiction in respect of those issues, when if Microsoft had actually claimed an injunction to restrain, plainly the CAT wouldn't have had jurisdiction.
That begs the question, if the defence to the claim had been that the exercise of the right was an abuse of a dominant position and or an unlawful set of restrictive agreements, so that you just turn the case around, it would have been the same question as to whether the CAT would have jurisdiction in those terms, whether the High Court could then have transferred it on the basis that really this was you getting your retaliation in first for, because you were predicting an antitrust claim against you.
But
It's really the flip side.
Yeah, but my lord, the consequence of the CAT determining these issues is that there would be a raised, let's just say there would be a raised judicata in respect of the copyright question. So that if there were subsequent litigation, one couldn't say that Microsoft could, or either party could relitigate those issues. And we say it is a surprising outcome and something that Parliament, ultimately we say Parliament couldn't have intended, the CAT to be making substantive determinations as to parties' rights and obligations in this way. And that's why we say the dividing line is, we say it's too formalistic for the judge below to say, because he accepted, certainly in the course of argument, that a claim for damages for copyright infringement and so on couldn't be within the jurisdiction of the CAT. And we say the only difference here is that there isn't actually a specific prayer for relief in respect of copyright.
blindingly obvious answer that I suggest is that this isn't brought by way of a copyright claim. It's brought by way of a defence to a competition claim. And that's why the CAT has jurisdiction.
Well, my lord, I follow the point, but we say that does lead to a very broad jurisdiction on the part of the CAT.
And what you could have done is you could have brought an infringement claim in the Patents Court, and then sought to raise by way of case management how those two claims would have to be managed, whether they would have to be tried together in some forum, but you didn't. You brought it by way of a straightforward defence to the competition claim. Why didn't you start, if you say this is a separate cause of action on copyright, why not bring it in the Patents Court as you could have done? And then you could have made an application in both claims and said, right, we've got a problem now because these claims have to be determined with a view to the other, but you didn't do that. So why having brought it by way of defence to the competition claim, are you not now? How can you complain about the way that it's now being dealt with?
Well, the particular facts of this case, I mean, I think you've seen the procedural history to this case and the way in which the jurisdiction point arose. But there were, in fact, earlier proceedings in the High Court between the parties in respect of copyright. And again, I mean, that doesn't, as it were, alter the argument. I mean, the argument's one of principle. But we do say, again, that just demonstrates in practice on these particular facts, it demonstrates the oddity of the CAT having jurisdiction and essentially dealing with the very same issues that were, at least at one stage, being litigated in the High Court. I mean, there's no question that a freestanding claim would have to be brought in the High Court.
There's no enormous issue about matters being dealt with in the CAT or the High Court. I mean, all of the interchange fees litigation, some was dealt with in the CAT, some was dealt with in the commercial court. There's no great dividing line between the two. Very often it's a High Court judge who's sitting in the CAT. It can be. So that's not the issue here. It's simply, as you say, it's simply interpreting legislation. You seek a rather extreme position that although you brought this by way of defence to a competition claim, it can't be determined in the CAT.
Well, my lord, I want to show you the Sport Radar case in a moment, because that's just a demonstration of a case where there was no. Well, I'll come back to it, but I understand what you're saying. But we do submit that it does lead to an incredibly broad jurisdiction on the part of the CAT.
I don't know why you say broad. I mean, it's just its jurisdiction is what it is. It either has the power to deal with ancillary, non-competition law issues, whether or not they give rise to a cause of action or not. I mean, it either does or it doesn't. It's not really broad. It's just, I mean, we just have to determine what its genuine and proper scope is.
But yes, my lord, but it's broad in the sense that it, as I say, on this basis, it would lead to the CAT determining substantive rights and obligations that otherwise would have to be litigated elsewhere. And the reason it's important.
It might not be problematic at all if, in fact, you can get a properly qualified judge. But it's not suggested you can't. It's what heads of division and listing officers do every time. You find a judge who's specialist, and you can do that in the CAT.
Of course you can, but my lord, that in my submission, that point shouldn't inform the construction of the statute, because ultimately what the.
But you're saying it's odd. I'm not certain I see that it's odd.
Well, because because it depends on the availability of judges and so on. I mean, one can't guarantee that one's going to get a judge with the expertise. I mean, ultimately the question.
In the patent court.
My lord, Parliament intended the CAT to be set up and to have an additional jurisdiction. It's not saying claims can't be brought in the High Court. So in my submission, the consequence of our argument is actually not one that leads to great difficulty, because all of these claims could be brought in the High Court and could stay in the High Court. If there is something in a competition case that needs to be litigated elsewhere, then one could have bifurcated proceedings in the way that occurred in Sport Radar. So although it's been described, my argument's been described as extreme, in fact, the danger is in overstating the extent to which this point actually comes up. And I do maintain that this is actually a very rare situation where we have a case raising non-competition issues in this way and to such a degree. I mean, there aren't actually very many examples. I mean, intellectual property is one example of a non-competition area of law overlapping or intersecting with competition law. But even within IP, I would suggest this is an extreme case.
There's a sense in which you make a lot of submissions about it. It's very rare. It's very odd. Whenever then it's put to you that maybe countervailing, you say, oh no, but it doesn't matter. It's a matter of statutory construction. It seems to be you can't have it both ways. Either one looks at the reality of the position and whether it's practical or not, or one doesn't. Or one just looks at the statutory construction or one doesn't.
But my lord, with respect,
Both ways.
well, with respect, I don't accept that one can't reconcile the two. I mean, Parliament had a general intention, I say, that the CAT should determine competition claims, and I say this case is particularly rare and unique and so on, which reinforces that Parliament wouldn't have been intending this kind of rare case to be within the four corners of the CAT's jurisdiction. So when one's looking at Parliament's intention, one has to look at the general thrust of competition claims, and that's why I stress this is a rare one. Because otherwise the danger is saying, yeah, well that's really the point. I'm not sure they are irreconcilable.
If Parliament sets a particular jurisdiction for the CAT, why shouldn't it intend that a claim that falls within that jurisdiction rarely should be within its jurisdiction? I don't see the logic of that argument.
Yeah, well, that may be that. Yeah, I mean, well, perhaps I should just take you to the couple of cases that we do.
Before you do that, I don't want to make you give you the sense that you're off the hook. Just if you cast this point, put it into the abstract, see whether it's an intellectual property issue or a competition law issue. The issue we're dealing with is factors which go to the determination of a relevant product market for abuse. And two of the factors might be what is the activity which the person who is alleging abuse lawful, and who is the proprietor of the right to prevent use in this product market. So those, I'm taking out intellectual property, I'm trying to define the issue in terms of just ordinary issues concerning the definition of a market. Isn't that what we're concerned about? Just defining what is the relevant market, is it affected by the legality of the activity of the claimant or defendant, as the case may be, and is it affected by the nature of the right held by the person alleged to be dominant, and whether they can enforce it to exclude people from that market. Those are classic antitrust questions, aren't they?
Well, but my lord, it comes in, I mean, I think we say that this point comes in at different levels of the competition law analysis, as I sought to demonstrate on the pleadings. But if one takes, perhaps for this purpose, one can just focus on causation. So it's common ground that there is no viable causal chain that can be pleaded if everything that value licensing has been doing is illegal. Now, if that's right, there is no obviously competition claims being breach of statutory duty and tortious claims. There just is no claim. I mean, in a sense, one can frame it in that way. That the breach of Chapter 1 or Chapter 2 is pursued by way of a breach of statutory duty cause of action in English law terms, and you cannot bring a claim, and it's common ground if there's just no causation if this was all illegal. So in one sense, that I'm not, as it were, trying to wriggle off the hook, but one doesn't need to get into precisely at what level of the competition law analysis does this come in, because the most simple answer is to say, well, let's just focus on causation. There is no causation or loss if we're right that they were in breach of copyright.
Understood. But it's also the case you've taken us to the pleadings, which
Yes.
focus upon the legality of the market.
Yes.
So
No, but the legality of the market. Sorry, my lord. Sorry. Just the legality of the market is also the causation point. So one has a debate about whether or not the market and their activities are lawful, and then the question is why does that dispose of the competition claim? So it's the same. I'm sorry. We may have been at cross purposes. I was also talking about the legality of the market. But what we've pleaded is the legality of the market is also a problem for them in relation to market definition and showing an appreciable impact on competition and so on. But the freestanding question, we say, that arises as a matter of pure copyright law is the legality of the market.
So if you go back to parliamentary purpose,
Yes.
in circumstances where an important component of the definition of abuse, namely relevant product market, turns upon analysis of related proprietorial rights, you're saying it can't be determined by the CAT.
Well, my lord, again, that's focused. Can I just show you section 47A? Because it's authorities, tab 2, page 8. So what this does is it confers jurisdiction upon the CAT in respect of claims of a kind specified in subsection 3, which a person who suffered loss or damage may make in civil proceedings. And then it's in respect of an infringement decision or an alleged infringement, and that's just to deal with follow-on and standalone. It's page 8, my lord, of the authorities.
Sorry, tab.
Tab 2, page 8. Does your lordship have the authorities for the jurisdiction appeals?
Looking at the wrong field. Yours is nice and short.
So this is 47A, and so the position is obviously, in order to have a claim, what's accepted is that VL of value licensing need to establish that they've suffered loss or damage, and they accept that if the market is unlawful, then they won't be able to advance a case.
That doesn't mean they haven't got a claim, though. You have a claim, and in the context of determining that claim, you may have to determine numerous issues. But the fact that there is
Yes.
an issue which may mean they haven't got a claim doesn't mean there wasn't a claim to stop.
Yes, but my lord, so we say essentially the CAT can determine all sorts of non-competition issues that might arise in the context of a claim, but there's a dividing line where those non-competition issues are such as to amount to a cause of action in their own right, because then one's in the world of essentially the Competition Tribunal dealing with exactly the sort of case that ought to be litigated in the High Court on the IP list.
So the language of 47(2), as applied to the present case, this is a claim in respect of an alleged infringement of Chapter 1 and 2.
That's correct. That's
Then,
correct.
then according to this, there is jurisdiction.
Yes. That's obviously what the other side is saying, and that's what the judge
So
believes.
where's the carve-out for
No, there's no-
subcomponents of that claim?
No, I understand. I mean, there's obviously no express carve-out, but that's why one's in the territory of a purposive approach to construing this.
Then you're rewriting, you're creating an exception, which you've defined as causes of action raised on proprietary rights, which could give rise to an independent cause of action.
Yes.
And you're implying that very specific caveat into section 47A(2).
Well, yeah, I mean, the answer is yes, and I can't, as it were, I can't say anything else. I mean, that is the position. The words don't have the carve-out that we're advancing, but we would also submit that this is not, as it were, wording that necessarily supports what the other side is saying either, because it's all question begging.
But it doesn't help you. It doesn't help you though to carve out something in 47A(2), because 47A(2) doesn't provide the jurisdiction. The jurisdiction is from 47A(1). A person may make a claim. So all that matters is that a claim falls within the definition of 47A(2). It doesn't matter that there may be other claims which aren't being made that don't. If somebody has a claim, makes a claim which falls within 2, then there's jurisdiction.
Yeah, well,
So you can do what you like. You can say that any number of other claims that don't fall within 47A(2), but if there is a claim that does fall within 47A(2), then there is jurisdiction under 47A(1).
yeah, but so subsection 1, a person may make a claim to which this section applies. and then 2 is this section applies
Before the tribunal, the key words are before the
Yes,
tribunal.
yeah. No, this is all about, yeah, absolutely. This is all about, so essentially, but this is permissive in the sense that one can always go to the High Court.
Yes.
But what this is saying is you can also go to the CAT if you have a claim to which this section applies. And then 2 is saying this section applies to a claim of a kind in subsection 3, which a person who has suffered loss or damage may make in civil proceedings. So in other words, if you've suffered loss or damage and you could make a claim in civil proceedings, and then it's either follow-on or standalone, you can go to the CAT. But it's not saying you're bound to go to the CAT. And we submit, it's not saying where non-competition issues arise to this degree, the CAT can
But it's
deal with
not
all of that.
concerned with issues, is it? It's concerned with claims.
That's what it's concerned with competition claims, my lord, because the claim is in respect of an infringement decision or an alleged infringement.
But all this on the face of it, all this section does is say someone may make a claim in the CAT if it falls within those provisions. It doesn't say anything about what may be raised by way of defence.
No, but my lord,
or what issues may arise on that claim.
But it's common ground now. It's common ground. In this particular case, it's common ground that they will not be able to show loss or damage if we're right on copyright. So that's why it's common ground that the competition claim. Yes, have they brought a competition claim? Of course they have. I'm not trying to shirk away from that. They've brought a competition claim.
So it falls within section 47A1 then.
But we say, my lord, we say 2 things, as I've tried to explain. We say, first of all, Parliament wasn't intending the competition claims, the conferring of jurisdiction on the CAT in respect of competition claims, to mean that the CAT could suddenly essentially determine rights and obligations unconnected to competition law. That's why I stressed that this is a rare case where the CAT's being asked to do that.
But nobody is saying that any person is making a claim. The claimant's not objecting to you advancing your defence in the way that you are. It's you say somehow, because you've brought a defence which could be brought by way of an intellectual property claim, that somehow they are not bringing a claim to which this section applies. That must be your argument, mustn't it? Because otherwise it's straightforwardly within 47A1.
But my lord, we would still say, as you know, our alternative argument is still that it's circular for this, because the competition claim here can only be pursued if VL's right about copyright. We do say it's circular. So you have the starting point is the copyright claim would need to be brought in the High Court. The very same issues are now in the pleadings in the CAT. And what Mr. Turner has held is the CAT can deal and has jurisdiction over those copyright issues, which would otherwise have to be litigated. And that's why we rely on the anterior point. Because actually, in this particular case, there is no claim. I see the time.
I was going to say, I see the time too, and I think it might help if you took us to the cases you wanted to show.
Yes, I'm conscious we're supposed to have a short transcribers break.
We need that.
No, let me just very quickly show you what we say about Unwired Planet and Sport Radar. Unwired Planet is it's in the authorities at tab 14. And I'm sure you're familiar with this case. It's referred to in the judgment below, but essentially Unwired Planet brought patent infringement proceedings. The defendants counterclaimed alleging a breach of contractual frowned obligations and also a breach of competition law. And the question, because some of the defendants applied for a transfer, the question was whether there should be a transfer from the High Court to the CAT. And so this is actually not on all fours with our case. I'm not seeking to suggest it is on all fours with our case. One can see at paragraph 20 what was being construed as section 16 of the Enterprise Act. It was one of the transfer provisions. And it was a question of what the infringement issue was. That's paragraph 20. And then the reasoning that I just want to show you is really 39 through to 44. And your lordship's obviously particularly familiar with this case, but 39.
So I've forgotten this judgment.
So, my lord, 39. The question was whether the court had jurisdiction to transfer the contractual FRAND issues, and it's clear that the competition law issues were infringement issues. And then you'll see Samsung's submission. They were seeking the transfer. That so much of the proceedings relates to an infringement issue were wide, and if given a purposive construction, were wide enough to include all the FRAND issues. And then at 40, Samsung submitted the words were clearly wide enough to transfer issues such as the correct construction of the MSA, which fell to be decided as part of a decision. I agree, but that sort of issue necessarily falls to be decided in order to address the infringement issue. And then you say it's different from the contractual FRAND issues, which, although they raise closely related considerations, are legally distinct. And nor can it be said that contractual FRAND issues are merely consequential or ancillary. And then it's 44. So you say, I don't have the luxury of avoiding making a decision. In my judgment, the words construed purposely and giving them as wide a meaning as I can are not wide enough to transfer for determination a distinct cause of action, which is not itself an infringement issue for it to be determined by the CAT. Their purpose was not simply to empower the court to transfer the whole proceedings. On the contrary, they only empowered transfer of so much of those proceedings as relates to the infringement issue. And then you say they demonstrate while they're legally distinct questions, the contractual FRAND issues do not relate to an infringement issue in the sense that they need to be addressed in order to decide any infringement issues. Rather, the two things interrelate. And then you say patent and contract claims ought to be decided by the High Court. The fact that the specialist expertise of the CAT could be usefully brought to bear in grappling with those issues, since they're so closely intertwined with factors which arise under competition law, does not mean they can be transferred. The CAT is a specialist tribunal for dealing with infringements of competition law. Nothing in the Act or the regulations demonstrates any intention by the legislator to broaden the scope of its responsibilities beyond that. So I obviously accept this is different from the present position. So what one had there was an allegation in the counterclaim of a contractual FRAND breach and a competition law breach. And what's being said is that they're legally distinct, they're separate. And
Which is a point the very learned judge makes in paragraph 41.
Yes.
It wasn't raised as a defence. FRAND. It was freestanding.
yes. So they were freestanding, but what we rely upon is the fact that there are limits when construing the legislation, and we say it's not the same in the sense that the copyright cause of action is legally distinct. It's not independent. I understand that point, that distinction, but we say there is a distinct cause of action applying the Latang and Cooper test.
Just looking at the paragraph 44 that you showed us and at F, the sentence starts, the contractual FRAND issues do not relate to an infringement issue in the sense that they need to be addressed in order to decide any infringement issue. There, the judge in question seems to be thinking, I think it's fair to say, that if they were issues which needed to be addressed in order to decide an infringement issue, then they would be transferred, or they could be.
Yes.
But isn't that flatly against your case?
Yes, I do understand it, but the point arose in a different. No, I do understand.
No, I mean,
Yeah.
yes, I mean, it's not binding on us. Don't worry.
No, I do
Binding
understand.
on me. It's just,
No, I do understand that, and certainly Mr. Levy, I think, says if you don't accept the way the judge below put the point, you should essentially adopt this sort of formulation, which is, do they need to be addressed in order to decide the claim? So I do understand that aspect is against me, but I do say it's helpful in the sense that one's recognising that there are limits to the scope of the legislation and the specialist expertise of the CAT and so on.
Okay.
And then can I just very quickly show you the Sport Radar case, which I've mentioned, which is at tab 15. This is less of less relevance, but it's relied upon by Value Licensing, so I just want to say something about it. And just in headline terms, so the claimants had brought, the claimants offered various sports betting services to bookmakers, and it was a competition law claim brought in the CAT, and one can see the allegations at 16 to 21, but importantly there was a counterclaim at 22. They were produced in draft because it was common ground that the counterclaims couldn't be brought in the CAT for jurisdictional reasons. One sees that at 22. And a summary of the counterclaims is 24 through to 26. It's tortious, so trespass, think conspiracy, there was also breach of confidence, one sees at 25 and 26. So there are these draft counterclaims, which everyone accepted were outside of the jurisdiction of the court, of the CAT. And at 27 to 29, what's being said is Sport Radar's defence to the counterclaims was the competition law allegation. So that's what they were going to say by way of response. And then, again, this was a transfer case, so it's interpreting different legislation. So one can see at 30 the legislation against section 16. And then we rely upon this, 35 to 36, guiding principles. CAT's a specialist tribunal set up to deal with matters of competition law and so on. And then there's a reference to what Mr. Justice Barling held or said in Sainsbury's, again, about competition law being a specialist area and a specialist tribunal and so on. And then what's referred to in value licensing skeleton is actually paragraph 43. So if I just take you to 43. And by letter D, you'll see standalone competition proceedings under section 47A will often raise legal issues outside pure competition law. I consider it most unlikely this would serve as a good ground for transfer out of the CAT. And then there's a point about a High Court judge acting as chair. If the defence to a competition claim raised questions of intellectual property law, the judge chairing the tribunal hearing may be no different. And so this is the point that we say one needs to be careful about raising questions of intellectual property law. So value licensing rely on this, but we say, and I won't repeat the submission, that there may be all sorts of questions of intellectual property law that arise in competition claims which don't satisfy the cause of action test or the dividing line that we say should be applied. So we say that's not, as it were, the ultimate answer to this. And then what the judge ultimately decides, if one looks at 54 to 55, the judge says the indicative counterclaims would, in the absence of a transfer, have to bring by way of separate action in the High Court. Sports Radar raised by way of defence to those counterclaims the same competition law argument. And then between letters C and D, resolution of that competition law argument is necessary for determination of the counterclaims. And then in the next paragraph at letter E, once it is appreciated that defences to the counterclaims raise the same competition issue as raised in the CAT, and this is a distinct issue from other issues, I consider it's clear that absent special considerations, a claim which directly raises this issue should remain in the CAT. So what the upshot in that case was, you had a competition law claim in the CAT, you had counterclaims in the High Court outside the jurisdiction of the CAT, but in that case, those counterclaims, the viability of those counterclaims depended on the competition law answer. And so it was, as it were, the competition law claim was anterior to the conspiracy, breach of confidence, and so on, counterclaims. And so what the judge has said is that the competition claim should stay in the CAT, because that will ultimately be the answer to the counterclaims as well. And at 67, you'll see the procedural solution of the judge, paragraph 67. The appropriate way forward, having regard to the governing principles, is for the tribunal having the conduct of this action to be chaired by a High Court judge. Once they bring their claims in the High Court, which the tortious ones, those proceedings can sensibly be docketed to the same High Court judge, and then there can be a joint CMC. And then the final sentence of different jurisdictions can be made to work together. And so what we say about this is this demonstrates that there may be some fragmentation, and again, one needs to be careful in portraying our argument as extreme. It doesn't render lots of claims unworkable as the
Neither
respondents.
of these authorities are considering jurisdiction under section 47A, are they?
I agree.
They're looking at transfer, and as Mr. Justice Burse, as he then was, said in I think it's paragraph 42 or 3, when you transfer, there's no problem over jurisdiction. So neither of them have anything to do with jurisdiction, do they?
Well, there is a jurisdictional question that did arise in. I mean, I do accept that in relation to Sport Radar, I do accept that Unwild Planet was a transfer case, but you will have seen ultimately that gave rise to a question of whether the CAT had jurisdiction to take. So that hard-edged question.
Not a section 47A
No, of course, I accept that. I accept that. Those are the only cases that have been relied on. And can I just finally say something about Wolfson? So the Wolfson interveners have put in written submissions, and we would just make 3 short points. The first, because ultimately we say what they put in doesn't really add to the question that you have to determine. So the first point is they say that you need to look at not only section 47A, but also section 47B. And they say, in fact, the position under 47B is a fortiori. And we say section 47B, as it were, is irrelevant, because section 47B, I can show you that, it's back in...
Tab 2, page 12.
Exactly. If I'm grateful. You'll see that actually I'm sure the court's familiar with this, but what 47B allows for is an aggregation of claims under 47A, to which 47A applies. So we say ultimately this is a question of construction of 47A. It's not in the territory of construing 47B or anything different. And then the next point I wanted to make is that they make great play of the fact that if we're right about this point, this would substantially undermine the effectiveness of the collective proceedings regime. And I've already explained to you why I say that's, with respect, overstated, because it's very rare indeed that this sort of non-competition issue would arise in the same way that has arisen in this case, particularly bearing in mind the cause of action test that we say applies, and also the anterior point. Very difficult to think of many examples. And so that's just an interorum submission, we say. And then the final point we would make is that ultimately not all collective cases will be certified in any event. I mean, one's seen that in recent case law. So one has to just construe the legislation. And if there are consequences for particular sets of collective proceedings, then that may well be how the statutory regime works. And in any event, there's a particular dispute between the parties as to what the impact of this appeal would be in the Wolfson case. So my lords, unless I can assist further. Well, that's what I would say.
Can I just ask, this is your amendment to the existing defence, which you are saying there's no jurisdiction to determine, is that right?
Well, that's certainly the no jurisdiction point would cover those amendments, yes.
What else is there no jurisdiction to deal with?
Well, this goes back to whether the point arises out of the defence or out of the claim. But the reply, for example, there's the 22-page reply. We would say all of that is...
That's a reply to an amendment which you applied to make.
Yes. I don't know if your lordship will recall that there is a point about whether or not Microsoft could have taken this jurisdiction point earlier, and that goes into the detail of the procedural history. It was ultimately accepted by both the judge and ValueLicensing that we weren't precluded from running the jurisdiction point at this stage.
So you applied to amend, and now you're saying that there wasn't jurisdiction to allow the amendment?
Well, jurisdiction in respect to the issues, yes. I mean, I do understand the consequence of the argument is that those points in the defence are outside of the jurisdiction of the CAD. There is a lot of procedural history, but we were very transparent with the court below that this jurisdictional point affects not only value licensing but other cases, including potentially Wolfson. So
I'm slightly struggling at the moment how you can apply to amend and then turn around and say the court doesn't have jurisdiction to deal with that amendment.
yeah, well, that goes to whether we're precluded from running the jurisdiction point, and as I say, that it's accepted that we're not as a result of the procedural history. I mean, I don't.
If you win the jurisdiction point, what happens? That defence is excised from the proceedings.
Then those issues need to be litigated in the High Court. Yes.
There's like a difference between our substantive rights and the procedures.
But also, unless I can assist further.
No, thank you very much, Mr. Singer. Yes.
Morning, my lords. The 2-minute version of my submissions. Section 47A gives the CAT jurisdiction to decide, it says this in clear terms, claims for damages, claims for injunctions, and claims for declarations now, after 3A came in respect of alleged infringements of competition law. And that's the chapter 1 and 2 prohibitions. And in my submission, that means, and can only sensibly mean, that it has jurisdiction to decide all of the factual issues and all of the legal issues that are necessary to decide in order to decide such a claim. And I do use the word necessary. That's the hard boundary. And I say that's the boundary because if the CAT did not have jurisdiction to decide all of the factual and legal issues that it's necessary to decide in order to decide a competition claim, then its jurisdiction to decide competition claims would depend on the legal taxonomy of the various issues and sub-issues and sub-sub-issues from which the claim, or as in this case, in my submission, the defence, is built. And that would be impractical, unprincipled, and I end with this, but it's really the starting point, contrary to what Section 47A actually says. Now, focusing on the claims in these proceedings, my lords, this is squarely a claim for damages and a declaration in respect of an alleged infringement of the Chapter 1 and Chapter 2 prohibitions and the TFEU equivalents, but I think it's common ground that doesn't change the analysis. There's some complicated transitional stuff around Brexit, but fundamentally it's the same point. The CAT has jurisdiction to decide the claim because it is a claim for breach of the Chapter 1 and Chapter 2 prohibitions. The jurisdiction extends to deciding the copyright issues that arise for the simple reason that their determination is necessary to decide the competition claims. And with respect to the Microsoft position, characterizing the point as anterior doesn't really alter the analysis. I mean, the fact is the copyright issues are one of the sets of issues that need to be decided in order to determine whether the competition claim succeeds or fails. I mean, one may as well say that the question of abuse is anterior. I mean, it is in the sense that you could choose to litigate it first, to try it first, and if it goes one way, that's the end of the competition claim. So there's really nothing in that point. So that, in a nutshell, is my submissions, my lords. I propose to expand on them, starting with the question of principle, which is essentially ground 1 of the appeal, and then considering how that applies to this particular case, ground 2. And in light of some of my learned friends' submissions, it is important, actually, to consider the principle first before one applies it. What is the boundary of the jurisdiction? It's no good in my submission to start from the other end and effectively ask, is this the sort of case that we think might be better in the High Court or the CAT? I mean, that's a question of case management, but that's not the question before your lordships on the appeal. The question is the hard-edged jurisdiction one. So the logical starting point is, where is the boundary of the jurisdiction? Your lordships have already seen 47A, but could I ask you to go back to it again, please, in the authorities bundle at tab 2, page 8? Because this is the most important page in all of the bundles in my submission on this appeal. And it is worth actually going through step by step. My Lord, Lord Phillips has already made the point about subsection 1, effectively defining the scope of the jurisdiction. If one then looks at section 2, which is where my learned friend focuses his attentions, it says this section applies to a claim of a kind specified in subsection 3, which a person who has suffered loss or damage may make in civil proceedings in respect of, etc. So subsection 3 is really rather important. There are effectively 2 limits to the jurisdiction. The first is it has to be a kind of claim specified in subsection 3, and then the second one is at subsection 2, it has to be in respect of an infringement decision or an alleged infringement, which is where we are in this case. But subsection 3, the claims are a claim for damages, any other claim for a sum of money, or in England and Wales or Northern Ireland, a claim for an injunction, and then over the page at 3A one has a declaration which came in later. Now, that is really rather important because putting it all together, what it means is if a party has a claim for damages, which is the case here, or a claim for an injunction, which is also the case here, or for a declaration, which is also the case here, and if that claim for damages, injunction or declaration is in respect of an alleged infringement of the prohibitions, which this claim is, then there is jurisdiction to decide it. Now, what does that mean, to have jurisdiction to decide it? Well, it must mean to have jurisdiction to decide all of the issues and all of the sub-issues that are necessary to decide it, because if you can't do that, then you are not able to decide the claim. And so the question of whether individual issues are issues of competition law or not, or whether they might be characterized as a cause of action or not necessarily an easy question in some cases, is really by the by, because there's nothing in section 47A that limits the jurisdiction to issues of competition law or to issues of non-competition law that don't amount to causes of action. It extends quite simply to the types of claims that I've identified. That's what the statutory language says. Now, that, on a fair reading in my submission, is also what the tribunal decided. Could I ask your lordships to look at the ruling paragraph 13, which is core bundle tab 6.
Can I just ask you about principles of statutory interpretation?
My lord, yes.
So the appellant's argument is there's an implicit exception which comes in through a purposive construction of section 47A. The exception has to be, it's a caveat to the scope of section 47A1 and 2. It creates an exception where, in order to determine an infringement decision under chapter 1 or 2, a necessary component involves the determination of some a priori proprietary right. Yeah. So it's a very, very specific implied exception in circumstances where you otherwise have to decide that point to determine whether there's an infringement. So it's a question of interpretation. We've got to ask ourselves whether Parliament would ever have intended that. And so normally you don't imply an exception into a statute when you have a broad provision already covering it, because then you've got an inconsistency. And that's a fairly well-established principle of just ordinary interpretation. So don't we just have to stand back and identify precisely what would be the statutory caveat and ask whether it's inconsistent with any other provision in the statute?
Well, my lord, yes, but the starting point in my submission is that there, if one's going to say there is some sort of implied exception, well, firstly, what actually, on analysis, is the scope of that exception? Because, my lord, it's not quite right, I think, on my learned friend's submission, that one does say, well, the exception is for proprietary rights, because, as I understand it, my learned friend's saying, well, no, it's fine for the tribunal to make decisions involving, for example, the subsistence of a right.
It's narrow. It's a proprietary right which, if determined as part of the competition law claim, could give rise to an independent cause of action. So it's even narrower.
My lord, yes, and
but that's what we have to imply in.
Yes, and the rhetorical question is, well, what on earth is the purpose of that? It's an arbitrary distinction, which has no purpose. Because what it would mean is, well, one can take the example, actually, of the very common example of the contractual interpretation. It's common ground that construing contracts is something the tribunal can do in the course of deciding competition claims. But what if, and I submit this is not a far-fetched example, what if one carefully analyses the pleadings, whether it's the claim or the defence or reply, whatever, on one construction of the contract in question, someone's in breach. There's no claim for it. But there we have, on the face of the pleadings, a potential cause of action for breach of contract. Does that suddenly mean that the CAT can't decide the point? Where is what is the principle which puts the dividing line there? What's the purpose? So I do struggle, my lord, to understand how one even gets off the ground with an exception to the clear language, because there's no driver for that exception. There's no inconsistency that's been identified which says, well, this can't possibly be what Parliament intended, because it doesn't work. It does work.
It's more than just an exception, isn't it? It's not being suggested that the CAT loses jurisdiction over the claim. The test is a person may make a claim. That's the competition claim. It's not being suggested that that jurisdiction is lost. What is suggested is that the CAT somehow doesn't have jurisdiction over an element of the claim.
My lord, yes, some parts of it, or in this case, some parts of the defence, which then have to be shipped off elsewhere.
It's hard to see how you could even, where you would even insert any words to do that, because this is not dealing with issues. All it says is, this is only dealing with who may make a claim.
My lord, yes, and what I suppose is quite interesting is it's because it's framed in that way. It's about what the parties can do. It's a claimant can make a claim. It doesn't, in terms, define, I suppose, the jurisdiction of the tribunal. It doesn't say the tribunal may decide claims of types A, B, and C. But I do submit it as a matter of interpretation. It's pretty obvious that if a person may make a claim under 47A, then it must be that the tribunal can decide it. And so then the question comes, okay, well, are there parts of it or some issues within it that can't be decided and have to go off elsewhere? And in the absence of statutory language which says that yes, you do indeed have to do that, well, on what possible basis? I mean, that's the way I'd put it now.
I suppose you would imply in section 47A, after the words before the tribunal, brackets, to be determined in accordance with its own rules. I mean, I think it must, when it uses the word before the tribunal, it's assuming it is the tribunal that determines the claim.
My lord, yes. Yes. But there's nothing in the rule.
Well, it actually says subject to the provisions of this
It
Act
does
and the
indeed,
tribunal
yes.
rules. So,
Yes.
so there you are.
Yes, exactly. And there's nothing in the rules to suggest that one can't deal with issues which arise in the context of competition claims, which are necessary to determine, in order to determine a competition claim.
The CAT has the power to transfer.
Yes.
It could have done so. The question here isn't whether it could have done so, it's whether it was required to do so and lacked jurisdiction to determine that component.
My lord, exactly right, because actually a lot of the points raised by my learned friend ultimately might be arguments why on certain cases an application might have been made under Rule 71 or possibly the other way around before the case arrived at the CAT, to say as a matter of case management it would be more sensible to deal with this case in the High Court, for example. But that's not what we're dealing with today. It's the hard-edged question of jurisdiction. Was the tribunal compelled, having received the case from the High Court, to transfer various issues back out again? And I suppose there's just nothing in the Act or the rules which leads to the conclusion that the answer is yes. And as a matter of principle, it would be very odd if the answer is yes, because it would be an impractical and an unnecessary impediment to the working of the tribunal.
Well, if Microsoft had sought to amend to include not only a defence but a counterclaim seeking declaration of infringement, then that would have been outside 47A1, because that would have been a claim which didn't come within the rubric.
Yes.
Short of that, all it's doing is participating in the claim according to the provisions of the Act and the tribunal's rules.
My lord, yes. And if there had been a counterclaim, then there would be case management questions that arise. Where are the copyright issues most sensibly determined? And what you may keep it all in the CAT and then go to the High Court for a declaration or some other remedy at the end.
They couldn't bring a counterclaim.
Well, they could, but they just couldn't bring it in the CAT.
Yes.
So it would be like the sports radar case.
So it wouldn't be a counterclaim.
I suppose that's right. It would be an additional claim on the similar issues, and there would be a question to ask as to where
Then there
those
might be
issues
case management issues for the two tribunals.
My lord, that's absolutely right. Yes.
Isn't that contemplated by section 47A5?
My lord, yes, I suppose because to bring any other proceedings in respect of the claim, and that could be by either party.
You have a right to make a claim in proceedings under the section. That doesn't affect the parallel right to bring other proceedings in respect of the claim. So
No.
it's without prejudice to your right in the CAT. So there could be other bits which might be determined elsewhere, but that's a matter of it's the right to bring. I mean, you could bring the proceedings, Microsoft could bring proceedings in the High Court, but then it would be a matter of case management, how it's dealt with.
That's exactly right, my lord, yes. But as I say, I mean, here, the position we're in is that no application was made to transfer anything. No claim in copyright infringement has been brought in these proceedings. And here we are, we've had the preliminary issues trial, and now arguing as to effectively whether that was all a nullity, but there's nothing in the statute to suggest that it was. And that's a totally different question from how one might have managed the claim differently if different applications had been made.
Mr. Lally, just focusing on subsection 2, 47A again, I'm sorry to take you back to it. I've not noticed before that it refers to civil proceedings. You see that in the second line.
My lord, yes.
Subsection 2. This section applies to a claim of a kind specified in subsection 3, which a person who has suffered loss or damage may make in civil proceedings brought in any part of the United Kingdom in respect of. Might it be said that the claim in this case involving, as it does, let us say, the question of copyright, could be brought in the High Court in civil proceedings? There would be no jurisdictional problem with that. And if that's true, it's still a claim in respect of an alleged infringement, which could be brought in civil proceedings in any part of the United Kingdom. So why couldn't it be brought in the CAT in that case?
Well,
one might say.
No, well, that's right, my lord. One has a choice. It could be brought in the High Court. It could be.
I suppose the point I'm trying to make is that whether the words brought in civil proceedings is doing any work on identifying the scope of the kind of claim which can be brought in the CAT. If it's the kind of claim which could be brought in civil proceedings in a court,
Yes.
then it could be brought in the CAT.
Provided it's in respect of. Yes.
It is in respect of alleged infringement, which this claim is clearly in respect of alleged infringement.
And that's, of course, the oddity, my lord, because the claim is squarely and only about an alleged infringement. And as my lord, Lord Phillips has noted, actually, yes, it is true that paragraphs 20 to 22 plead in the background section that there's a lawful market, but that wasn't a necessary part of the cause of action. It's in the defence that all the issues arise around copyright. And so, yes, I think for what the word civil proceedings are doing, my lord, is making clear that there really are only the two limits to the jurisdiction under 47A. The first is it has to be a claim, as in someone seeking a remedy as defined in subsection 3. And it has to be in respect of one of the two, a decision or an alleged infringement. And that's all. Provided you're falling within that bucket, the claim may be brought. And so where, I ask rhetorically, does it say that not all the issues in the claim that's been brought can be decided? Now, I mean, what's quite interesting, I'm sort of leaping ahead, as it were, in my note, because I'm conscious of the time. But if one looks at this claim and this defence, the issues, my learned friend sort of slightly elided the different issues, because it may be convenient to refer to, say, the copyright issues, but actually there are different sets of copyright issues. If one asks oneself in respect of the preliminary issues trial issues, well, do they reveal a cause of action? Well, my lords, plainly actually, no, they don't. What they're about is what rights there are as a matter of law, how exhaustion works, and why are those things interesting? Because they tell you something about the market in the counterfactual, what would have happened in the counterfactual, and so on and so forth. It's actually only a very narrow bit of the pleading which goes so far as to actually allege infringement of copyright, and that's, my own friend did take your lordships to that, it's 24A to D. and at 24D, there's the plea that Microsoft could have sought to strain an infringement. That's actually a rather inchoate pleading in itself, because although certain aspects of the copyright issues are not in dispute, of course there's no plea of qualification so far as I can see. There's no identification of specific works with any particularity. There's no identification of the specific acts which are said to infringe specific rights. Is one talking about the distribution right, the reproduction right, and so on? So it's not, this falls far short of, the defence falls far short of what you would expect in an actual claim for copyright infringement. And one can actually see, because of time, I don't want to take your lordships the detail of the pleading, because I don't think it really matters for my point. Beyond this, one can actually see scope for dispute about whether or not what appears in the defence amounts to, or is sufficient to amount to, a cogent claim, a cogent cause of action in copyright infringement. And the reason why that's interesting is because it rather tells you it's a rather strange test that Microsoft suggests is the right test. Because the question of whether pleadings reveal various causes of action can be far from straightforward. I mean, one can imagine, for example, various economic tort type issues which aren't advanced as claims, but on one reading of a pleading, you might say, hang on a second, actually, if one looks at the facts as pleaded in this way, it may be that there's a tort in there somewhere. And it's the same in a way with these copyright issues. So one has to be a little bit careful.
You said, I think you said 24, did you say 24A to D? There isn't 24D.
Have I got that wrong? Let me just get the right reference.
Just make sure I know which paragraph.
That serves me for trying memory instead of turning out the document. Yes, so can we start, please, my lords, at page 249, tab 16. I'm not going to go through it the way my learned friend did, but just to flag, 23A is a whole load of pleadings about the law. No cause of action there. That's effectively a set of submissions about the legal position. And then 23B sets up consequences, or the alleged consequences of that position.
I see. Mr. Levy, you probably said 23 and I thought I heard 24.
No, I think I did say 24, my lord, because 23C is quite an interesting creature. Because if one looks at 23C insofar as it deals with copyright, and my learned friend has taken your lordships to the relevant passages, or the relevant passages for the preliminary issues, I'm trying to go to 23C1 and 23C 3 and 4. Now, those in my submission, although I can see it's arguable, probably don't amount to causes of action. Because if one looks at, for example, 23C subparagraph B on page 256, what one sees is, despite this being the rights and the way they say various things work in this particular point, the way the divide and sell works, the claimant's case is based on the erroneous assumption that there exists an unfettered right to acquire such subdivided portion of the user right from the first acquirer, and so on and so forth, where no such right exists. So that is not a plea of a cause of action. That is a plea which goes to effectively the size of the available market in the counterfactual, because it's a plea that goes to what one is and is not allowed to do as the first acquirer of certain types of software sold in certain types of ways. And the reason why I said 24 is, and I meant 24A on page 259, because this section, which is not the subject of the preliminary issues, is the closest one actually gets to a plea of infringement. And what one talks about, this is about specific licenses that have been acquired, and if one goes all the way down to 24A5, which my learned friend showed your lordships before, it's further to be inferred that all or substantially all of the claimant's sales and or brokered transactions, save those involving CALs, involve purported resale and acts of distribution and or reproduction or authorization of the same, etc. Which acts Microsoft is entitled to restrain as copyright owner in respect of which it could have brought an action for copyright infringement. Now, just parking the question of that, whether that is a sufficient plea, bar the prayer, which I say it probably isn't, that is the closest the pleading actually gets to talking about an actual situation of actual alleged infringement. Most of the copyright issues that arise in this case don't amount to causes of action because they're not about actual infringement and actual facts, but they're about the market in the counterfactual and what value licensing could have done in the counterfactual and so on. So, I have some diffidence in talking about or making submissions on Unwired Planet, given who the judge was. But in my submission, the key point is the one that's your lordships have already remarked upon. What your lordship said in that case is not if you have a cause of action, it can't be dealt with in the CAT. The word your lordship used was distinct cause of action. And the key point was, why is distinct so important? Well, what one was dealing with the Frand issues was a totally different cause of action in respect of which there was a claim. It was not a claim for infringement of the prohibitions, it was a claim for breach of contract. And that is common ground. It is not something that the CAT could deal with. And so really, I submit that authority is full square consistent with value licensing's position in this claim, albeit your lordship wasn't actually dealing with this question, precisely this question of jurisdiction. But what one actually sees in that case is an example of how the world works in practice. There was a very complicated piece of litigation with lots of moving parts, some of which could have been dealt with in the CAT, and there was an application to transfer. Other bits of it could not have been dealt with in the CAT. Then the case management question is how best to deal with that case, and your lordship made a decision on it. But if the very narrow issue of jurisdiction, as I submit, it's actually very, very plain what your lordship was deciding. And that jurisdictional boundary of necessity was there in Unwired Planet, just as I submit it's there here, because that's what section 47A sensibly construed must mean. Now, the intervener's points, my lord, I mean, given that leading counsel for the intervener is here, rather than massacring his submissions, I'll simply commend them to your lordships, and obviously if there are any questions on them, the intervener can answer them. But I think, yeah.
Sport radar?
Well, in a way, not really, my lord, because simply because I think it's all been said. I mean, sports radar is an example of a case where you have some issues that did fall within the jurisdiction, some issues that didn't fall within the jurisdiction, and it's another example of having to have a case management decision as to how one is going to deal with the various bits of that case. But I suppose none of that arises here, and the reason why none of that arises here is because if one actually stands back and looks at this and asks oneself, well, what are the claims being brought here? There's only one claim. It's a claim for infringement of the prohibitions. It's a competition claim, and that is the long and the short of it. Now, although I do have a sort of another 15 odd pages of notes, my lords, in a sense we've covered the ground through your lordship's questions, and so unless you have any further questions, those are my submissions.
Thank you very much, Mr. Labby.
Thank you.
Mr. Williams, we'll give you 5 minutes. Would you
Right.
like to say anything in response to Mr. Singleton?
I'm grateful, my lord.
Sorry.
So, my lords, I'll use my 5 minutes to respond to the 3 points that Mr. Single made towards the end of his submissions. His first point was that section 47B is irrelevant, he said, because all section 47B does is aggregate together claims that are made under section 47A. And we of course accept that the primary question is how to construe section 47A. The reason section 47B is relevant because of the consequences of the Microsoft argument, because it is part of the Microsoft argument that their interpretation of the statute doesn't preclude claims from being made in the tribunal. What it does is require that non-competition law issues are transferred to the High Court for determination. That's paragraph 71 of their skeleton. And this is really an attempt to soften the blow of the argument and to turn this into a question of process or logistics rather than substance. And the submission we make is that if that consideration had any force, it has no force for collective proceedings, because Rule 71 of the Tribunal's rules doesn't apply to collective proceedings, and Microsoft doesn't shrink from saying that this point means that the collective action can't proceed at all. So if one focuses on collective proceedings, then we say that does put a very different complexion on the way that Microsoft presents the case in its skeleton argument, where it says this is just a matter of process. We say that if one focuses on collective proceedings, it's a matter of access to justice rather than a matter of process. And the tribunal has in the bundle the Merrick's case, which is Supreme Court authority concerning the purpose of the class action regime. To give you some references, it's paragraph 20, authorities 13, paragraph 20, 37, 45, 92 and 98. And those paragraphs all stand for the proposition that the class action regime exists to provide access to justice for claimants for whom an individual action wouldn't be economical or practicable. And one does have to ask whether it's likely that Parliament intended there to be such a stark difference in the scope of the individual and collective actions that could proceed before the tribunal. And we say the answer is clearly no. Again, in our written case, we've referred to Merrick's as authority for the proposition that the court should be slow to find a barrier to a collective action that would not apply to an individual action. That's paragraph 9 of our written case, citing paragraph 45 of Merrick's. And we do say that it's most unlikely to have been Parliament's intention that certain forms of collective action can't proceed in the tribunal in circumstances where an individual claim alleging the same abuse could proceed. So that's the first point. The second point is Mr. Singler's refrain. This is a rare case which shouldn't trouble the court too much. And we also respond to that in our written case. It is not uncommon, we submit, or exceptional for competition law claims to involve the analysis of issues that arise in other areas of the law. There's been an argument before the court about, for example, contract law, but if one looks beyond that, we've referred in our written case to 3 cases, Meta, ND and Gutman. That's tabs 19, 23 and 24 of the bundle. And the first 2 of those cases involve issues arising under data protection law. And the third raised an issue, or almost raised, I should say, an issue of consumer protection law. And the legal issues that arose in those cases are capable of giving rise to distinct causes of action. The GDPR can be privately enforced. Consumer law can be enforced through the courts by public and private enforcers. So these are further concrete examples of areas of law which may arise in a competition law case and which on Microsoft's interpretation would fall outside the tribunal's jurisdiction. The examples are not isolated based on the authority of the Court of Justice in the Meta case, which we've referred to in our written submissions, because Meta establishes, I won't take the court to it unless you want me to, but it establishes a general principle at paragraphs 47 and 48 that compliance with the law in another area, not competition law, but another area of the law, is a relevant consideration when one is determining whether conduct constitutes competition on the merits, which is a central component of the legal test for determining whether conduct is abusive. And for that reason, we say that questions of law that arise in other areas are intrinsically relevant to the abuse analysis in such cases, and it follows that the tribunal must be able to consider them. It doesn't matter whether or not the facts alleged are capable of constituting a cause of action in a different area of law, and the fact that the copyright issues in this case are central doesn't call the tribunal's jurisdiction into question. It's all part of the competition law analysis, and the tribunal must be able to consider it. So that's our response to the second point about whether these cases are rare. The tribunal has the Gutmann case. That was a case in which the class representative came close to alleging that the alleged abuse in that case constituted an infringement of consumer law. They didn't actually advance that case squarely, and in the circumstances the tribunal didn't determine the issue, but it was clear that in principle whether the conduct was an infringement of consumer protection legislation was a relevant consideration in determining whether the conduct was abusive. The reason the tribunal didn't determine it is because the case hadn't been squarely advanced in that case. So those are my submissions on the second issue. The final point Mr. Singler made was that there will be cases which won't be certified for other reasons. And in my respectful submission, that's obviously true, but that has nothing to do with the question of the tribunal's jurisdiction. I hope I've kept to my 5 minutes.
Hold on, Mr. Williams. Thank you. Mr. Singler.
Well, I can be very brief in reply. I mean, ultimately, we say 47A refers to claims in respect of infringements and breaches of competition law.
Yep.
And we do say that needs to be construed, and we don't. We submit Parliament didn't intend to go as far as to say that issues of non-competition law, which amount to a cause of action, are within the jurisdiction of the CAT. And just breaking down really what we say into some propositions. I mean, the first proposition is it would not be permissible to bring a claim for copyright infringement in the CAT. That would have to go to the High Court. In this case, all of the relevant facts have been pleaded, as would be pleaded in a copyright infringement dispute, only that no injunction or specific relief has been sought. And we say point 3 is in this particular case, if we are right about copyright, then there is no claim for competition law. And we say, with respect to the judge below, it's a circular conclusion to essentially assume the viability of the competition law claim. The jurisdictional result he's reached is to say there is a competition claim on foot. And we say that's not right unless and until one knows the outcome of the copyright issues. We do say this leads to odd results. It leads to a specialist competition law tribunal making substantive determination about rights and obligations that are not to do with competition law. It creates an issue estoppel, so one couldn't then litigate in the specialist IP list these copyright matters. And we say it's particularly odd because one would then have a determination from the CAT, but we wouldn't be able to follow through and claim the relief that flows. One would have to go to the High Court to claim that relief. And we do maintain this is a rare case. It's unlike the GDPR cases that Mr. Williams just referred to. In those cases, what's being said is you've breached GDPR and that's relevant to whether or not there is an abuse. We say that fails, the analogy that he's seeking to draw fails to understand the particular circumstances of this case. And we do say the submissions from ValueLicensing and Mr. Williams are in terrorum in terms of undermining.
Just on that point, why isn't the same issue estoppel issue, as it were, about the breach of GDPR as there would be for the copyright on the example you gave? Isn't it the same?
Well, my lord, so the Gutmann case, in fact, it wasn't GDPR and it wasn't even pleaded, so it's a slightly difficult case. But in hypothetical terms, if what's being said by a claimant is that you've abused your dominant position, and one of the factors I'm going to rely upon in that regard is that you've also breached your GDPR, that wouldn't satisfy our cause of action test, because what one's not seeing in the pleading, but in that hypothetical pleading, is a plea that would amount to a cause of action under GDPR, because one would also need a plea of loss. And as far as I'm aware, in those cases, one's not actually pleading out all of the facts that would entitle one to a remedy under GDPR. So in those cases, what's being said is there's a loss caused by the abuse, and a relevant factor to whether there was an abuse was just the mere fact of a breach. We say here, we're on the other side of the line in terms of the cause of action test, because all of the facts have been pleaded, as would entitle us to the injunctions and the declarations and so on.
Okay.
So, well, unless I can assist further.
You want to read your junior's note? Oh, there you go, the life of the junior. Thank you very much to Mr. Singler. You follow?
No,
Thank you. Right. Well, thank you very much indeed. We will rise now and sit again at 2 o'clock and we'll hear the next bit of the case. Thank you.
All rise in favour.